Hello and welcome to Courts Today by LifeLaw. Let's get to today's top legal updates. Supreme Court Bar Association election results to be recounted. Supreme Court rejects RTI application for copies of in-house inquiry report and CJI's letter to President and PM on Justice Yashwant Verma. Karnataka government moves Supreme Court against direction to release TDR to royal family heirs over Bangalore Palace acquisition. Supreme Court orders status quo on liquidation of Bhushan Steel Power Limited to allow JSW to file review petition. Delhi High Court issues summons to Abhijit Iyer Mitra after Newslaundry seeks to continue defamation suit for his absolute lack of remorse. District judge's retirement age can be enhanced to 61 years. Supreme Court to Madhya Pradesh High Court. I am your host, Syed Amir Hussain, with your daily roundup of legal updates from across the country. For detailed reading, you can always visit www.livelawlaw.in. Please make sure to watch this video till the very end. And don't forget to like, share and subscribe to our channel because your support means the world to us. LifeLaw Premium subscription starts only at Rs 1099 plus GST. Subscribe now. The Supreme Court was told today that the results of the recently held elections for the post of the Supreme Court Bar Association will be recounted in view of some complaints. Senior Advocate Vijay Hansaria, the member of the election committee constituted by the court, told a bench comprising Justice Recount and Justice Dipankar Datta that on complaints of senior advocates Adish C. Agarwala and Pradeep Rai, who contested for president, the committee found irregularities in the counting process. He informed the court that a recount would be conducted, with the Registrar General appointed as an observer to ensure transparency. The bench said that immediately after recounting the votes for SCBA president, a report should be submitted to the court without declaring any results. Justice Kant asked not to declare the results after recount as the court would like to see if it's fair after recounting. During the hearing, the bench also expressed displeasure with Dr. Adish Agarwala, who was appearing virtually. Justice Kant said that any attempt to browbeat the members of the election committee cannot be tolerated, as they are like extended arms of the court. The Supreme Court has declined a right to information request seeking access to the in-house inquiry report concerning allegations against Justice Yashwant Verma. The in-house inquiry was initiated by the then CJI Sanjeev Khanna following the accidental discovery of a large sum of cash at Justice Verma's official residence. A committee comprising chief justices and senior judges from 3 different high courts was formed to examine the matter. While preliminary materials included photographs, videos and responses were made public, the final report has been kept confidential. The RTI application filed by Amritpal Singh Khalsa on May 9th also sought the letter sent by the Chief Justice of India to the President and Prime Minister while forwarding the inquiry report. The court's Central Public Information Officer rejected the plea, citing the 2019 Supreme Court judgment in CPIO Supreme Court of India versus Subhash Chandra Agarwal. The reply emphasized that the information is protected under sections 8(1)(e) and 11(1) of the RTI Act, which deal with fiduciary relationships and third-party information, respectively. The court highlighted that disclosure would violate principles like judicial independence, confidentiality, and privacy. Justice Verma, previously a Delhi High Court judge, has since been transferred to the Allahabad High Court and is currently not handling any judicial work. The Karnataka government has approached the Supreme Court seeking to challenge its recent order directing the issuance of transferable development rights or TDRs to the heirs of the former Mysuru royal family. The TDRs, worth approximately 3,000 crores, relate to 15 acres of Bangalore Palace grounds acquired for a road widening project under the 1996 Bangalore Palace Acquisition and Transfer Act. Though the Supreme Court had issued the direction in contempt proceedings on May 22nd, the state has now filed an application in the main appeal, pending since 1997, arguing that TDR provisions were only introduced in 2004 and cannot be applied retrospectively. Representing the state, senior advocate Kapil Sibal contended that Section 14B of the Karnataka Town and Country Planning Act, which allows TDRs, applies only when landowners voluntarily relinquish land, not in cases of acquisition. Sibal pointed out that the court's order bypassed this legal issue and allowed a contempt petition to effectively amend judicial conclusions. He argued that the matter merits urgent hearing to prevent irreversible consequences, especially since the TDR certificates have reportedly already been handed over to the claimants. CJI Gavai expressed concern over whether a new bench could revisit directions issued by another bench, but agreed to list the matter. The court will now consider whether the TDRs granted can be stayed or reversed in light of the state's objections and claims of retrospective illegality. The Supreme Court has ordered a status quo on the liquidation proceedings of Bhushan Steel and Power Limited before the NCLT in response to a plea by JSW Steel. The move comes shortly after the court had on May 2nd quashed JSW's 19,700 crore resolution plan for BPSL, citing violations of the Insolvency and Bankruptcy Code. A bench of Justices B.V. Nagaratna and Satish Chandra Sharma noted that the limitation period for JSW to file a review petition is still open, and any steps toward liquidation could prejudice that right. Senior advocate Neeraj Kishan Kaul, appearing for JSW, pointed out that the NCLT was proceeding to appoint a liquidator even though the review deadline ends on June 2nd, while the Solicitor General Tushar Mehta for the COC suggested deferring proceedings till June 10th. Ex-promoter Sanjay Singhal opposed the plea, arguing JSW's review route was procedurally flawed. The court, however, clarified that it was not commenting on the merits but granting interim relief in the interest of justice. Previously, the Supreme Court had directed liquidation of BPSL under Section 33 of the IBC, finding the resolution plan non-compliant with Sections 32 and 31(2) and holding both the COC and the NCLT at fault for approving it. Meanwhile, Sanjay Singhal has urged the NCLT to implement the Supreme Court's liquidation order and begin the process under the IBC. The Delhi High Court today issued summons to commentator Abhijit Iyer Mitra in a defamation case. The case was filed by 9 women journalists from the digital news platform Newslaundry. They said that Mitra posted abusive comments on X, calling them prostitutes and referring to their workplace as a brothel. The journalists who have filed the case are Manisha Pandey, Ishita Pradeep, Suhasini Biswas, Sumedha Mittal, Tista Roy Chowdhury, Tasneem Fatima, Priya Jain, Jayashri Arunachalam, and Priyali Dhingra. Newslaundry is also part of the case. Mitra had already taken down most of the tweets after the court hearing last week. Today, the court asked the lawyers if the journalists still want to continue with the case. The lawyer, advocate Bani Dikshit, confirmed that they do. Mitra's counsel said the tweets were now deleted, so the case should be closed. But the court said that since the women are asking for damages, the case will go on. The judge also said the court will not look into Mitra's written reply today. The court noted that the matter is now mostly about compensation. It also said that if Mitra posts anything defamatory again, the women can file another application. Earlier in the day, Dikshit told the court that 2 tweets were still being circulated even though most had been deleted. The judge reminded Mitra's side that posts like those cannot be justified and that such language against women is not at all acceptable. Last week, the court had refused to hear Mitra until the posts were taken down. Mitra's lawyer argued again that all posts had now been deleted and asked for the case to be dismissed with costs. But he even said that there should be an investigation against Newslaundry, claiming that the platform had made insinuations about the Indian Prime Minister. But the bench said that such concerns can be raised in a separate case. As long as Newslaundry's content is within the limits of free speech, it is allowed. The court made it clear that now that Mitra knows where the limit lies, he is expected to follow it. The judge also said there might not be much left to decide in the case since the posts have been deleted. However, since the journalists want to continue the suit and seek damages, the case will proceed. The court has given Mitra time to file his written response. The Supreme Court clarified that there is no legal obstacle in increasing the retirement age of district judges in Madhya Pradesh to 61 years. The court directed the Madhya Pradesh High Court to take an administrative decision on this issue within 3 months. The case was being heard by a bench comprising Chief Justice B.R. Gavai and Justice Augustine George Massey. It arose from a petition filed by the Madhya Pradesh Judges Association, which has been requesting an increase in the retirement age of district judges in the state. Initially, in 2018, the association had made a representation before the High Court seeking enhancement of the retirement age. However, the High Court rejected the request, citing the 2002 judgment in the All India Judges Association case, which it believed did not allow such a change. The Supreme Court, while hearing the matter, referred to a more recent application filed by Telangana government in the same All India Judges Association case. In that matter, the Telangana High Court had sought clarification regarding increasing the retirement age of district judges to 61 years. The Supreme Court had then observed that there was no bar on doing the same. Based on that clarification, the Supreme Court today observed that there is no impediment for the state of Madhya Pradesh to enhance the retirement age of its judicial officers to 61 years. The court made it clear that if the High Court of Madhya Pradesh takes a decision in favor of increasing the age, such a decision will be completely permitted. The counsel appearing for the Judges Association informed the bench that although the original request was to raise the age to 62 years, which would bring judges in line with government officials whose retirement age was earlier 60, the association is now only seeking enhancement up to 61 years. The Supreme Court concluded by asking the Madhya Pradesh High Court to consider the issue on its administrative side as soon as possible and to take a decision within a maximum period of 3 months.